So once you've opted for the diversion, what happens next?
Once you have the diversion recommendation from the police officer, that will often be accompanied by a list of recommended conditions that must be complied with for the purposes of the diversion program. You, as Kristina's mentioned, you have the interview with the registrar of the Magistrates Court, and then the magistrate in chambers considers the application for diversion. So that means not in court, they consider it by themselves. The registrar comes back and advises you whether or not diversion's been granted. If it's been granted, you go into court and the magistrate will indicate at that stage what conditions they consider are appropriate, and they may want to hear from your lawyer during that process.
Kristina, what are some common conditions that are imposed?
Some of the most common conditions that are imposed with a diversion plan is a monetary contribution to a charity that either you can nominate or the court will nominate for you, a letter of apology to a victim if it's appropriate, and also a letter of gratitude to the informant for recommending you for diversion.
I see. So are there any that the magistrate might impose that weren't already in the recommended list?
Yes, that certainly can happen. For instance, if the magistrate considers it appropriate for you to complete a course, anger management or some kind of road trauma awareness course, depending on what the nature of the charge was. So the magistrate really has quite wide scope to impose whatever conditions they consider appropriate.
Susanna, what happens to your charges while you're completing the program, and how long do you get to complete the program?
How long you get depends. It's on a case-by-case basis. I've had matters where the diversion program has lasted for 3 months and circumstances where diversion has run for 12 months. What happens to your charges during that process is that the charges are sort of on ice, really. They still exist in the court system, but the diversion coordinator, the court receives evidence that you have completed each of the conditions, and sometime short time before your diversion program is due to be completed, they'll review the file, ensure that all of the conditions have been met, and once they have been met, on the particular day that your diversion program expires, it will be marked off as complete, and at that stage the charges will disappear.
If you re-offend at some point in time, will that come up in, say, the court record?
Yes, well, you're not one of the condition that will apply to every single diversion is that there's to be no reoffending during that period. So if you're not charged during that period, then your diversion will be completed and you won't have to return to court on that subsequent date. But if there are any charges filed against you during that time, then your diversion program won't be completed and you'll have to reappear before the magistrate on all of those matters.
I see. And what happens if you don't complete your conditions?
If you don't complete your conditions, then the matter is referred back to the Magistrates Court and you're dealt with in the regular stream of court.
I see. Is there any way that you can get that time extended? Because what if you end up having a serious car accident and you have some sort of impairment to be able to complete that?
Absolutely. Course? Yeah, if you make an application to the Magistrates Court and have it listed, a lawyer can obviously assist you with that process. The faster you get onto it, the better chances you have. But if you're proactive and have the matter listed at court, then the magistrate, any magistrate, has the power to extend your diversion in reasonable circumstances.
While you're completing the conditions, do you have to report to anyone? Susanna?
No, you don't have to report to anyone. There's a very clear list of conditions. You must provide evidence to the diversion coordinator. So, for example, where you are required to pay a donation to a charity, you have to either provide a receipt to the diversion coordinator or provide the diversion coordinator themselves with a money order to complete that donation. Similarly, with letters of gratitude or letters of apology, you send those documents directly to the diversion coordinator and then they ensure they are forwarded on to the appropriate people. So you don't have to report to anyone as such, but there's a person at the court who manages the program.
We've seen in recent times that the Victorian government is allocating funding towards youth diversion programs. What's the purpose behind all of that?
It's quite similar to the purpose behind the adult diversion program. It's an opportunity for a person to deal with a matter at court without having a criminal record result and follow from that. And so really the aim is for young people to be able to get through that difficult time in their life without it having a significant consequence of having a criminal record.
You have young people transitioning from school to apprenticeships or to employment, and having a criminal record really does make things difficult. So for low-level offending in the children's court, it serves the same purposes in the adult court.
They also find that if you can connect young people into appropriate therapeutic programs, then you increase the chances of that child becoming rehabilitated or just reconnected on the right path. And so they have found that it could also reduce the risk of reoffending.
Someone outside the legal profession may see diversion as a softer approach to justice. What would your comments be towards that?
In particular with children, people that are appearing in the children's court, they work on a different sentencing model essentially, where there's less emphasis on punishment and more emphasis on rehabilitation, because the rationale is that if you get in early, support that young person, then you set them up for the rest of their lives.
So essentially the court's view was to set a foundation for this child.
That's exactly right.
Try and help them through their life as opposed to give them a punitive sentence. It's essentially not going to add anything.
They've got a long life ahead of them, and so if you can support them, help them get through whatever difficulties they're experiencing, then you're putting them in good stead for their future.
Victoria is also the only state in Australia that doesn't have a formal diversion program in legislation as part of the children's court. So in a sense it's a little bit of catch-up, but it is important to note that at the moment the diversion program in the children's court is a pilot only, and it hasn't been funded yet for expansion throughout the entire state.
And what's the effectiveness of other states in their diversion programs?
I probably can't answer that question.
Kristina?
We have a program called ROPES, which is already being used in the children's court, but the idea behind the pilot program for youth diversion is to expand the opportunities that it can give young people.